Good evening, guys. Let's start with the lecture. So in the last e-lecture, we'd covered torts as far as torts related to persons are concerned. Today, we are moving over to the next relevant segment under the law of torts, that is torts related to property. As far as torts related to property is concerned, we are going to be doing three important ones, that are trespass to goods, detinue and conversion. For all those who are just joining us in, I'd like to quickly remind you that till the last session we'd finished torts related to persons. Today we are moving on to torts related to property. In the last e-lecture we had also covered the defenses as far as law of torts is concerned. So we are going to be doing trespass to goods. That's the first tort that can be committed against a person's property, followed by detinue and thereafter conversion. So let's take a look at the first tort that can be committed against a individual's property. Alright, let's take a look at the slide. What do you understand by trespass to goods? We understand the meaning of trespass as such that when you are present on another individual's property without his or her permission, because you can only be present on another person's private property if you are a lawful invitee or you are present on that property under some contract. Being present on somebody's property under a contract, an example would be when an electrician is called or a plumber is called, etc., etc., or where you need to get your house maintained or any kind of construction. So all these people are present on the property under a certain contract, right? And lawful invitees would automatically mean guests, the best example, right? Okay, now what do you understand by trespass to goods? The first line says wrongful or unjustifiable interference. Wrongful means something that you're not supposed to do, and unjustifiable obviously means something that you can't justify or something that you cannot explain logically. Now, how can you carry out this interference? You can carry out this interference by possessing the goods of another person that you're not supposed to possess. Now, it may include the taking out of the goods from the plaintiff's possession or causing damage to such goods. So first we are talking about a wrongful possession, then you take the goods out of the possession of a plaintiff. So this is very much on the lines of theft, or when you cause damage to movable goods that do not belong to you. Now, these are a few examples that I've quoted on the slide which are related to trespass to goods. One such example would be when you throw stones at a car. Now this is an example of when you damage a property belonging to another individual, right? Or beating an animal which belongs to another person. Now animal also happens to be the property of his or her owner. Now if you beat an animal or if you're throwing stones at a car, you're basically indulging in the trespass to goods. Removing the wheel of another's car, deflating a car or cycle's wheel, shifting goods belonging to another from its original position. So all these are examples of trespass to goods. So anybody who's indulging in A, when you conduct the wrongful possession of a movable property. Second, you take out a property from the possession of the person to whom it lawfully belongs to. And third, you cause damage to the property that belongs to another while it is still in the possession of that person. So through all these examples, I've tried to cover these three situations. Let's get to know a little bit more about trespass to goods. Now, what are the elements that you have to prove when you're trying to file a claim under trespass to goods? Well, the first thing that you have to show is the plaintiff must show that he had the possession of goods at the time of the trespass, because in the slides that have just gone by, we mentioned that if somebody takes out a movable property from your possession, then it is going to be trespass to goods. So the first and the most basic thing that you will have to prove is that you were in the possession of the good which was taken away from you or at the time of the trespass. Then the next element that you might have to prove is direct physical interference with the possession of the goods. How can there be a direct physical interference with the possession of the goods? Like throwing a stone at the car, or somebody beats up a pet that you own. All this is direct physical interference with your ownership of that particular property. The third element is the defendant must have wrongfully interfered with the possession of the plaintiff. Another example of direct physical interference could also be when you remove the wheel from a car or you deflate the tires of the car. Interfered with the possession of the plaintiff is again deflating tires would be a wrongful interference with somebody's possession, because ultimately you are interfering with the person's right to not only possess the property but to also enjoy the rights over that property. Yes, Anjani, plaintiff under the law of torts is the person who files the case or who files an application or a plaint, and the defendant is the person who actually has committed the tort, and such a person is also called the tortfeasor. Clear? Shraddha, thank you so much for answering that. Alright, now move on to the next tort that can be committed against a person's property. Detinue. Now, if you take a look at this word, it is very close to the word that is detention, right? So, wrongful detention by the defendant. So, defendant is the person against whom the case is filed by the plaintiff. So when the defendant is wrongfully detaining any good which belongs to the plaintiff. So detinue in short means wrongful detention. If you hand over a certain movable property to another individual and then that individual does not return the property to you, then it amounts to wrongful detention. Something that you really must pay attention to over here is that initially when you hand over the property to the defendant, you do it out of your own free choice, but later on when the defendant refuses to return the good to you, then that starting from that period when he refuses, it becomes detinue or wrongful detention. Let's take a look at this example which I've quoted on the slide. A gives a ceiling fan to B for repair. If B refuses to return the ceiling fan after a demand has been made for its return, it is going to be a case of detinue. Yes, Purnima, ma'am, would removing someone else's wheel come under private nuisance also? See, nuisance is to interfere with somebody's rights over immovable property. Okay, it's very important that you understand that. And this is when we talk about trespass to goods, we are only considering movable property. Alright, so private nuisance is mostly considered against an individual's right over a certain land or house. So we are usually considering immovable property under nuisance, and we've already discussed in the last lecture that there are two types of nuisance: public nuisance and private nuisance. When a larger group of people get affected, it's public nuisance, and when a very small section or one individual is affected, it is private nuisance. Shraddha, if we have time, because we also have to cover intellectual property rights and family law today, I'll try my best to cover as many queries as we can. Otherwise, you can always keep sending in your doubts at our email address. Clear? Yes, Shraddha, definitely, but I would want to once breeze through the most important facts. I want to finish torts today, move on to intellectual property rights and then family law. So it's going to be my effort to take up as many doubts as I can. Side by side, keep throwing in your doubts. I'll keep taking them in. Yes, Shraddha, I'm going to try. Okay, so just relax, smile and focus on the lecture right now. Okay, otherwise I'm always available to take up your doubts. You can always write into us and you're going to get a very quick response or an email from us. Clear? So don't worry at all about it. Okay, moving ahead. Let's delve a little deeper into the concept of detinue. Now again, as far as detinue is concerned, the plaintiff will have to prove ownership to the goods. The plaintiff must have made a demand for the return of goods. The defendant must have refused to return the goods. and the plaintiff sues for restitution of the specified goods and not merely damages. So if you look at all these elements, first you have to see the plaintiff has to prove ownership, that first of all when he handed over the goods belong to him. Thereafter another person should make a demand for the return of goods. Obviously then the defendant must refuse, and finally when the plaintiff files a case, he should sue for the return of that goods in addition to damages. Saima, as far as trespass to goods is concerned, it is a concept that we do under law of torts. Let me repeat it one last time, that law of torts is not a law as such, it is a collection of principles, and these principles have been adopted by various legal systems. So theft is a kind of trespass to good, and theft is a separate offense under the Indian Penal Code. Theft is without consent. Okay. Let me finish the tort section. I'm going to take up all these queries then. So hold on. Okay. Thereafter we have conversion. That's the third tort that can be committed against an individual's property. Now an act in relation to the goods of a person which constitutes an unjustified denial of title. So there are various ways in which conversion can take place. First of all is when you wrongfully take away the goods. Okay, first way is you wrongfully take a good from someone that you're not supposed to, then you dispose of the good to a person who's not entitled to them. So first of all, you've taken a good that does not belong to you. Secondly, you've given away a good to someone who it is not supposed to be given to. Say for example, A takes away something that belongs to B and then A gives it away to C. Both these are examples of conversion. Now, okay, Jovenpreet, I'm taking your doubt today. During the scarcity of onions, long queues were made outside the defendant's shop, who having a license to sell fruits and vegetables used to sell only 1 kg of onion per ration card. The queues extended on to the neighboring shops, and they filed a complaint. Okay, Jovenpreet, this is not going to be a case of nuisance because the facts tell us very clearly that there was a scarcity of onions and he was doing the right thing. So he was not wrongfully interfering with anybody's rights over their property. Clear? A person is an employee of another if the mode of Shraddha, this is vicarious liability, right? Okay. Messrs. Zafar Abidi and Company manufacturers BD with the help of persons known as the supplied tobacco and leaves by the company and required to roll them into BDs. They are free to roll the BDs either in the factory or anywhere else they prefer. They are not bound to. Okay, now in this case, he is not an employee of the company Shraddha as per the facts of the case, so the company is not going to be liable to him. Alright, because principle 1 says a person is an employee of another if the mode and the manner in which he or she carries out his work is subject to control and supervision. So in this case, the people who roll BDs, they are not under the control and supervision of the main company at all. Clear? Yes, Shraddha, and extortion presence is not required, but robbery has to be conducted personally. Alright, liability of owner for dangerous premises. Now, when you have a private property, what is your liability towards the people you invite or who trespass onto your property or towards children? So we are going to look at the liability from 3 perspectives. What is the liability of the owner of a property towards lawful visitors, followed by trespassers, and thereafter children? Okay, obligations towards lawful visitors. Now, a person enters the land of another in pursuance of a contract or an invitee. So you either have to be present on a private property under a contract or you should be invited. Now, what is really important here is that when you invite somebody onto your property, you must make sure that you take all necessary or reasonable care to ensure that the person who's on your property either under a contract or under an invitation is not hurt or does not suffer any kind of damage. This is exactly what the second point says. Reasonable care should be taken to prevent injury to the invitee from danger. Now please note down which he knew or ought to have known about. So there are certain dangers that you can reasonably foresee that you must guard your lawful visitors from. Obligations towards lawful visitors. Now I'm giving you an example of how you have to be obligated, or you have a sense of duty towards those who are present on your private property under a contract. Let's see this example. A, who was a gas fitter, entered the defendant's premises for testing certain gas fittings there. While doing so, he fell from an unfenced opening on the upper floor and was injured. Now, A, being an invitee on those premises, the defendant was held liable for the injury caused to him. What are the obligations towards a trespasser? Now, who is a trespasser? Let's get some clarity on that first. A trespasser is one who goes upon another person's land without invitation of any sort, and whose presence is either unknown to the owner, or if known, it is practically objected to. So if you're going to be on another person's private property without invitation, or you have no business being on that property, then you're going to be a trespasser. Now, as a general rule, an occupier is not liable towards the trespasser. Exceptions: occupier must not deliberately cause harm. Now we are looking at what is the responsibility of the owner of a private property towards a person who has entered the property unlawfully. What is the kind of action and what is the magnitude of action that he should be taking against the trespasser. Now once the owner of a property knows that an individual is present on his property, he should not deliberately or knowingly cause any kind of harm to him. Also must not act with disregard to the trespasser's safety if he has knowledge of his presence on his premises. So ultimately, like we've also done under private defense to property, that your responsibility or the only kind of leverage law gives you is that at that time it's your job to protect your property. So that does not always include causing unnecessary harm to the trespasser. So you must not act in disregard of the safety of the trespasser. Vanshika, in the previous example I've spoken about that if you have a gas fitter on your property, he's come onto your property to check gas fittings, and if he gets injured during that process, then you have to be responsible to him because he is present on your property under a lawful contract. Jobanpreet, we've discussed this example under nervous shock in the last e-lecture, so I would prefer that whenever that e-lecture goes live, you get some clarity on this example. I've covered it under torts related to persons under nervous shock. Shraddha, of course, if the thief is pretending to be a gas fitter, then he's going to be a trespasser and there's going to be no responsibility. Okay, obligations towards trespassers. Let's see this example. I've quoted an actual case here. Let's read it. The defendant was an occupier of a field adjacent to a railway station. Though the defendant objected to it, he took no effective steps to stop the practice. Meanwhile, the defendant bought a savage horse and kept it on his land without any notice. One day the horse attacked a trespasser who was seriously injured. It was held that the plaintiff, on account of the tacit permission from the defendant, had now been vested with rights of a licensee. Therefore, the defendant was liable for the injuries suffered by the plaintiff. So what really happened in this example is there was a person who owned a piece of land which was next to a railway station. Now, a lot of people used to use that land as a shortcut. So he put up a notice saying that trespassers will be prosecuted. But people still continued to use his property as a shortcut. So eventually, the fact that he did not actively do anything to stop those people from entering his property and using it as a shortcut, it implies tacit permission. Alright, so in this case, when one person while crossing from his property got injured, then the owner of the property had to pay him compensation. Purnima, I'm taking your query. If there is a fence around A's property and there's an open pit in his property, B trespasses. Now Purnima, we've done this under defenses under torts, that when the plaintiff himself is the wrongdoer. Now when he's trespassing into the property, and I just clarified it to you that you can only take responsibility towards lawful visitors. Okay, so he's not going to be responsible for the trespasser who falls into the pit. Tacit permission means that he has given him a sort of license, even though he put up a notice saying that trespassers are going to be prosecuted, but he did not actively do anything about it, so it amounts to giving a license, an implied permission. Alright, what are the obligations towards children? Now the occupier must take reasonable care to guard them against such dangers from which the adults do not need any protection. So ultimately you have to exercise extra care when you're dealing with kids. So the kind of responsibility that we're talking about increases in case of children. Let's look at this example. Glasgow company versus Taylor. A corporation maintained a public park. A child who had come to the park plucked a fruit which looked like a berry from the shrubs. It was poisonous and the child died after consuming it. It was held that the corporation was liable for their negligence in not fencing the shrubs. So we are talking about 100% liability towards children. Students, remember this as a thumb rule, that whenever we are talking about children, irrespective of the kind of care that has been taken by the occupier of a property, he will always be liable. Okay, now what is the liability of the owner of animals? Okay, so let's look at the first rule, Sainter rule. The owner of a dangerous animal is strictly, Jovenpreet, we are not taking any kind of queries related to Transfer of Property Act. Please try and stick to the course that we are doing right now. The owner of a dangerous animal is strictly liable even without proof of negligence for the damage caused by them if they escape. So if you own a dangerous animal, or if you own an animal who has dangerous tendencies, now there may be a dog from a species which is very docile, they are very harmless, but the dog that you own particularly is very ferocious. So you are going to be 100% liable in case he causes damage to anybody else. This is what the Sainter rule is, that if you have a dangerous animal, you will have to take complete responsibility for the damage caused by that animal. Examples are lions, monkeys, elephants and bears. In case of animals of harmless nature like cows, dogs, rabbits, cats, horses, camels, etc., the owner is liable for the damage caused by them only if it can be proved, like I just mentioned, that the animal had a vicious tendency and the owner was aware about that tendency. Anshuman, you will have to watch the last lecture, okay, on torts that can be committed against persons. Liability of owners for dangerous animals. Now the term cattle includes cows, bulls, buffaloes, horses, sheep, goats, poultry, etc. It does not include dogs, cats or wild animals. If any damage is caused by trespass of cattle upon the land of another, the owner is strictly and absolutely liable. Please focus on these lines as a thumb rule. If any damage is caused by the trespass of cattle upon the land of another, the owner is strictly and absolutely liable. Clear? Alright, now we come to the next important part under torts, that is the various types of liabilities. Vicarious liability is that scenario where somebody else commits a mistake and you have to be answerable for it. So the general rule is that if you commit a mistake, you have to pay compensation for it, or you have to face the punishment for it. Now, under vicarious liability, what happens is one party is held responsible for the tort committed by another. Now, respondent superior means let the superior authority respond or answer. Qui facet per alium facet per se. It means that when you act through another, then it is as good as doing an act yourself. What do you understand by vicarious liability? I've already clarified two important things to you, that vicarious liability is based on the concept of respondent superior. Let the superior authority respond or be liable. And second is when you ask another person to do a certain job for you, and if that person commits any kind of mistake while doing that job, then you have to take responsibility for it. Now, when you are making a third person liable for a tort that has been committed by you, there are certain benchmarks that have to be met. Okay. Now, what are those benchmarks? Was a tort committed in the first place? Then, was the tortfeasor an employee? And was the employee acting in the course of employment when the tort was committed? Okay, so if there are two parties, A, B and C. A is the employer and B is the employee, right? If B commits a tort while on job, because here we are looking at the term course of employment. So if he has committed a tort while he was acting in the course of employment, then A is going to be liable towards C if B has caused any kind of damage to C. Anshuman, I still have to do strict liability. Okay, please wait for it. So vicarious liability exists between the following. There is master servant. If there is a master servant relationship, the master is going to be liable for the tort that is committed by the servant. In a principal agent relationship, the principal will be liable for a tort committed by the agent. And in partners, the partners will be liable. If one partner commits a tort, then the rest of the partners are going to be liable for it. What are the tests to determine vicarious liability? Now, how do you make sure that the relationship of a master servant or an employer-employee exists between two people? Now, we have three tests mentioned on the screen. Please pay attention. The first test is hire and fire test. Hire and fire test is if a person has the authority to appoint someone on the job, that is hiring, and if the person also has the authority to throw a person out of the job or terminate his services, then it is hire and fire test. Clear? The second thing is also if the person has the authority to tell another person how he has to be conducting his job, then he fulfills the direction and control test also. And the last test that has to be completed is in the course of employment, which means that whatever tort is committed, it has to be committed while a person is on the job. So say for example, there's a school and a teacher is hired to teach the kids. Now if a teacher misbehaves with a student or beats up a student while the school timings, in that case the school management is going to be liable. But in case this teacher is taking private tuitions at home in the evening and then he ends up beating up a child, then the school management will not be liable, because at that time the teacher was not acting in the course of employment. So course of employment is very, very relevant. We are going to discuss a few case laws so that you people can get some more clarity as far as vicarious liability is concerned. Let's look at the first case law on the slide. Now these case laws that I am discussing with you, most of the principal fact questions are based on these case laws. So for all of you, my suggestion again would be that as far as torts, IPC and contract are concerned, read as many illustrations, examples and case laws as you can, because eventually the factual situations are going to be based on these cases. So I've picked up another popular choice as far as the CLAT paper setters are concerned. So this question is repeated very, very often in one form or the other in CLAT and other law entrances. Let's take a look. The respondent, Mrs. Shama Devi, opened a savings account with the bank. Shama Devi paid some cash and check to Kapil Dev Shukla in his capacity of her husband's friend, who was also an employee of the said bank. Instead of making the deposits, Kapil Dev Shukla got the check cashed and misappropriated the amount. No, Megha, you don't have to learn the titles of the case at all. Now in this case what has happened is there's a certain woman and her husband's friend happens to work in the State Bank of India. Now what she does is she handed over a check and some cash to the husband's friend so that he could deposit the same in the bank. However, the friend did not do so. So in this case she filed a case against the bank. Now when she handed over the check and the money to that employee, she was not trusting him as a bank employee, okay, or at that time even that man was not acting in the capacity of the bank employee. That is why the bank will not be liable in this case. Yes, Vanshika, you are right. In this case the bank was declared that it is not liable. Another case is which is very similar, but you'll understand that how during the course of employment makes all the difference when decisions related to vicarious liability are concerned. Now in this case, Mrs. Lloyd approached Messrs. Graith and Smith Company to seek investment related advice. Now here she is gone to a particular office, that is Messrs. Graith, Smith and Company, and she wants to seek investment related advice. Now the clerk who attended upon her asked her to sell her properties and then reinvest the proceeds. Now she is interacting with this clerk because she is actually visiting the office of Grace Smith and Company. So she is not really relying on the clerk, but she is relying on the management. So the clerks told her that you should sell your properties, and whatever money you are going to get after selling the properties, you must reinvest it. Okay, so Mrs. Lloyd signed certain documents. Now they were supposed to be the sale deed of a house, but it turned out to be a gift deed in the favor of the clerk. Now at this time, this clerk was acting in the course of employment, and Mrs. Lloyd trusted him because he was the clerk at this investment company. So that is why in this case the court held that Messrs. Graith, Smith and Company is going to be liable. Alright. Another case law, Bailey versus Manchester. Now another thing you must remember is sometimes the students end up getting confused that once you've been asked to do a certain task, whether you do it in the right manner or you end up doing it in the wrong manner, the employer has to take a responsibility for it as long as he asked you to perform that job. So this case on the slide is a perfect example of that. A railway company appointed porters to assist passengers to board the right trains. One passenger had got into the train in the right train, but a porter erroneously thought the passenger was on a wrong train. He therefore pulled him out and put him in another train. So in this case, the railway company that had appointed porters was liable. Okay, now this particular case that I've mentioned on the slide, I really wanted to focus on it. Twine versus Bean Express Limited. A provided a van for the use of a bank. He put up 2 notices on the van which read that no unauthorized person is allowed to take a lift in the bank. So basically a van was owned by a bank, and on the van 2 notices were put up that no unauthorized lifts should be given, and also there was an express statement for the driver also that you will not give any lifts, and another notice said that nobody should be taking any kind of unauthorized lift on the van. The driver nevertheless gave lift to an unauthorized person who died in an accident caused by the driver's negligence. Held that A was not liable for the act of giving lift was outside the scope of employment. So if you see in this case, the bank had given very clear instructions that no unauthorized lifts have to be given. In case they are going to be given, the bank will not take any liability. Now this is the approach that is being taken up by foreign courts. Now as far as the trend that is being followed by the Indian courts, that is completely the opposite of it. Okay, so in India, as far as unauthorized lifts are concerned, even if express instructions are put, the owner will still be liable. So please be very careful, because you can definitely expect one question as far as this trend that is being followed by the Indian courts is concerned, because in India, even if you give an unauthorized lift, you will still be liable to the person in case he suffers any kind of damage. Yes, Anshuman, in India the employer will be liable. Yes, Megha, as far as the Twine case is concerned, the driver will be liable. Okay, the next kind of liability is strict liability. Strict liability is no fault liability, and even if there has been no negligence or carelessness on your part, there is still going to be liability that is going to be created, which means that you will have to pay compensation even though you might claim and prove that you were not negligent or you did not intend any kind of harm. Now, Rylance versus Fletcher is this case which gave us the concept of strict liability. Before I discuss the facts of Rylance versus Fletcher with you, you must know what are the essentials in order to attract strict liability. What are the essentials that you have to prove? The first essential is that you have brought some dangerous thing onto your property. Eventually the dangerous thing escaped, and it should be a non-natural use of land. As far as this case name is concerned, Rylands versus Fletcher, you must remember, because you may be asked a direct question that in which case was the principle of strict liability laid down. Of course, your answer has to be Rylands versus Fletcher. Now in Rylands versus Fletcher, what happened? There were two sets of properties. On one property there were coal mines, and on the other property there was a mill. The owner of the mill wanted to get a water reservoir constructed on his property, and for that he hired an independent contractor. So when the independent contractor was digging up the water reservoir, he saw that some open shafts or pipes were running underground from the adjoining property. So instead of covering the opening of those pipes or shafts, he dug up the reservoir and he filled water in it. Eventually the water seeped in through those shafts into the adjoining property, and the owner of the coal mine, of course, suffered a lot of loss. So in this case, the principle of strict liability was applied, because the mill owner had two claims. That first, he was not actively involved in the construction himself. Secondly, he had hired an independent contractor to do it, so he should not be made liable to it. But the court said that as long as you brought something dangerous. Now water, depending on its magnitude and the object it is affecting, now water is definitely going to be dangerous for coal, right? So then it acquires a dangerous dimension in this case, and the water escaped onto the other property, right, or it seeped into the other property. That is why the principle of strict liability was applied. Yes, Anshuman, strict liability is also called no fault liability. That is why the very first point on the slide says that. Now, what are the exceptions? What are the defenses that you can still take up under strict liability? Well, the first defense is the escape happened because of an act of God. We've already discussed act of God and vis major under the defenses under law of torts. Or whatever damage took place, it took place because I had the consent of the plaintiff. So in the case of Rylands versus Fletcher, in this case, had they been able to prove that this reservoir was dug up with the consent or permission of the owner of the coal mine, then the case would have been different, or it was the plaintiff's own fault, okay, or wrongful act of the third party. So basically, either you prove that the result, the damage took place because of an act of God, or because the plaintiff himself gave the permission, or a third party was involved. Now we come to the last liability, that is absolute liability. Anshuman, strict liability is also no fault liability, and absolute liability is absolute liability. Absolute liability is the Indian version of strict liability. So absolute liability is not called no fault liability, strict liability is no fault liability, and absolute liability is the Indian version of strict liability. Now I've already told you that torts is a collection of principles, and every country has adopted these principles as per their need. So India, while adopting strict liability, converted it into absolute liability, and we in India have not given any such defenses like act of God, or plaintiff is the wrongdoer, plaintiff's consent, or act or action of a third party or a stranger. Now in this case, MC Mehta versus Union of India, this is how Justice Bhagwati justified the creation of absolute liability. Now he said we have to evolve new principles and lay down new norms which will adequately deal with new problems which arise in a highly industrialized economy. Now this concept of absolute liability has been very successfully applied in all environment related cases. In fact, it was applied even in the case of Union Carbide Limited versus Union of India in 1984. That is the Bhopal gas tragedy case. Reading further, we cannot allow our judicial thinking to be construed by reference to the law as it prevails in England, or for that matter in any foreign country. We are certainly prepared to receive light from whatever source it comes, but we have to build our own jurisprudence. So absolute liability means where we don't allow people to take any type of defense. So absolute liability is the Indian version of strict liability. Now moving on to the second part of the session, that is intellectual property rights. We are going to follow it up quickly by discussing family law. Alright, what do you understand by intellectual property rights? Of course, the word intellectual means something that is related to your brain, intelligence or intellect. So, we usually discuss, when we talk about law, we discuss either movable property or immovable property, but both movable and immovable property are tangible properties. Tangible property means something that we can see, we can touch and we can feel. But when we are talking about intellectual property rights, we are talking about creativity, okay, anything that is a product of your creation. Now the best example would be J.K. Rowling, who is the author of yes, what has J.K. Rowling written? Harry Potter, right? So the entire Harry Potter series is the creation of the mind of J.K. Rowling. She is a renowned author and this is her intellectual property, okay? She created this entire wizard kingdom just by applying her thought process, just by applying her creativity. So intellectual property rights, the concept has been created to basically protect the creative rights of people, okay? Whenever people create something by thinking differently, then they are the ones who should get benefit out of that creative thinking, or when they apply these ideas creatively. Now this is intangible property. Of course, we can't touch this property or we can't feel this property because we're talking about intellect or creativity. It's not movable or immovable. It is again the result of one's intellect or creativity. Intellectual property cannot be seen, however its manifestation is tangible. Now what do I mean by it? So when J.K. Rowling thinks of certain ideas, we can't see or touch those ideas, but when she actually pens it down on a book, that is when we can see the manifestation, or that is when we can see her ideas come to life. So whenever these ideas are brought to life, then we have to basically safeguard these final products, which are the result of an individual's thought process or thinking. So rights given over the creation of the mind. Okay, copyright. Copyright, you must have seen this sign at a lot of places. Every TV channel at the end of the show will show you Viacom copyrights reserved 2017. Now let us understand what is a copyright. Now this is the right that you get to make copies of a creative work. Okay. Now in case an author writes a book, it is going to be, he is going to get a copyright over it, just like I gave you the example of J.K. Rowling. Or when a musician makes a piece of music, he is going to get a copyright over it. Or when a singer sings a song, he is going to get a copyright over it. So basically, what are those type of works, or what are those category of works over which you can apply, or for which you can apply for a copyright? Well, these categories are literary, dramatic, musical, artistic works, or a cinematograph, film and sound recording. So basically for these 6 category of works, a copyright can be applied. So if you've created any literary work, dramatic work, musical work, artistic work, sound recording, cinematograph, film, you should apply for a copyright, because whatever commercial gains that will come out of it, only you have a right over it, so that nobody else enjoys unfairly the fruits of your creativity or the fruits of your intellect. Clear? Shraddha, I am going to discuss trademark after this. Okay. Now when you do get a copyright, what are the kind of rights that are going to be available to you? First of all, the first right is you will basically get to decide how the work is reproduced. Okay. Whether in a normal printed form or in any electronic medium. Second, you are going to also get a right to decide whether this work should be made public, okay, and copies should be produced of it. So if you write a book, you get to decide along with the publisher how many copies are going to be printed. Say for example 50,000 copies are going to be printed. So the publisher has to make sure that he gives you a certain amount of money when the books go into printing, and thereafter if the books are reprinted again, then again you are going to get a certain royalty over it. Similarly, you are going to decide in how many languages your work can get translated. Also, say for example, you've written a book, you'll get to decide whether the book can be dramatized. So in India, the most popular example is how Chetan Bhagat's books have been adapted into various Bollywood movies. So how a certain copywritten work has to be communicated to the public is also something that the owner of a copyright gets to decide. Then, just like I gave you this example of Chetan Bhagat, make any cinematograph film or sound recording in respect of that work and translation or adaptation of that work in a different medium or language. Clear? Now, what is the term of a copyright? If you apply for a copyright, for how long are you going to get that copyright? You will get that copyright for the entire lifetime of the author. Okay, so if a person applies for a copyright, he is going to be the owner of the copyright till the day he is alive, plus 60 years after that. So this has been given under the Copyright Act of 1957. Now, these are the most essential rights which are associated with copywriting a work. Right of publication, like we've already discussed, it is the owner of a copyright who gets to decide whether his work should be published or it should be translated into another language, or it should a dramatic version should be created out of it, or a cinematographic film should be created out of it, etc. The right of paternity means the right of ownership. The Copyright Act has been created to ensure that if you are the creator of any literary, dramatic, musical, artistic work, or a sound clipping, or a cinematograph film, you should be able to claim ownership for it, so that ownership of it, so that nobody else gets to commercially exploit your creative ideas. And the right of integrity means that you should be able to decide how your work should be put out in the public, how your work should not be tampered with or misused. Clear? Alright, the next type of intellectual property right that we are going to deal with is patent. So I told you that copyrights are given for 6 categories of work: literary, artistic, dramatic, musical, cinematographic, film, or a sound recording. Now, what are patents granted for? So patents are dealing with a different type of creativity. When you create something new, what are we talking about? What is this new thing that we are dealing with? We are talking about inventions. So patents are going to be granted for inventions. What type of inventions? Inventions that are novel, which means new, which have inventiveness. That means that you have done something for the first time differently. You cannot apply for a patent for something which has already been invented by someone, and it should have industrial applicability. That means that it should be capable of being used on a large scale. That means an industrial applicability. So that means when you create a patent, and when we talk about industrial applicability, that means that you have to have a clear-cut formula which leads to that invention. Only then it can have industrial application. So once that formula is set, no matter who uses that formula, the result has to be the same. So when your invention meets these 3 benchmarks, novelty, inventiveness, and industrial applicability, that is when you're going to get a patent. Now, the object of granting a patent is to encourage the innovator for new scientific, technological, and industrial advancement, which is going to be beneficial to the society at large. Now, how is a patent different from a copyright? Patent is different from a copyright in the sense that for getting a copyright, the author or the creator does not need to register himself with anyone. So as far as copyright is concerned, please pay attention to this, that once you've created anything that belongs to the 6 categories I mentioned, you don't have to immediately apply for a copyright. If there's a dispute later on, the only thing you have to prove is that you are the original creator of that work. However, in case of a patent, the minute you invent something, you have to apply for a patent. This is the biggest difference between a copyright and patent. Even if you don't apply for a copyright, you will just have to prove that you are the original author of the work. But in patent, you have to immediately apply for it. So just as the slide says, but in case of a patent, the patentee has to file an application in the patent office. Megha ownership of what? Megha by proving that he is the author of it. He has to have some proof that he is the first person who wrote this story or who had this idea. Ideally, now the courts encourage that copyright should also be sought immediately. But if you don't seek a copyright, you have to have some proof to show that you were the creator of the literary, dramatic, musical, artistic, sound recording or cinematographic film. Clear? Who can make this application for a patent? Of course, the inventor, right? Or somebody he has given the authority or right to file for a patent, or his legal representative. Clear? If somebody else uses your invention, when you invented something, Anshuman, then only you get to decide how that invention has to be used. If you are not going to get a patent for it, and if somebody gets his or her hands on your formula, he will commercially exploit something that is the result of your creativity, your intelligence or intellect. This is how patents are infringed. Clear? Now, as far as the assignee under the patent law is concerned, you can assign your rights completely to another individual. So whenever there is 100% giving away of your rights associated with the patent, you assign the rights. And licensee is whenever you basically only give a certain right associated with your patent. So say for example, you allow a certain company to manufacture a product based on your invention, but you don't give away all the formulas associated with it, all your research work associated with it. But when you assign a patent, you give away the entire ownership. Now this is really important. Vanshika, assignee is when you give away all your rights related to your invention, and licensee is when you only give a few rights. Clear? Use of patent without license by the government. All the patents are granted with the condition that the government shall have the right to use the invention. So the government, whenever you assign your patent to someone, 1970 Anshuman, whenever you assign your patent to someone, that person has to pay royalty, okay, over it. Now, in case of the government of that country, the government does not have to pay any kind of royalty, and the government also reserves the authority to use the patent at any point of time, and the last point tells you they may or may not pay royalty depending on the situation. Clear? Now, what is the term of a patent? The patent is granted for 20 years, and after that period of 20 years is over, the invention, the research behind it, the formula, they all enter in the public domain. So remember, the term of a patent is 20 years, and after 20 years your invention becomes public property. So that means anybody can make use of that invention. So you must be very careful as far as the terms of patents are concerned. Now we come to the final type of intellectual property right that we are going to discuss today, that is a trademark. Now, you must have seen that the market is flooded with so many goods and so many services. So, trademark is basically a combination of words, letters, colors, figures that are used in order to make a product or service distinguishable or identifiable from a distance. So, if you see Nike shoes, they use a swoosh. Okay, or if you look at McDonald's, the way M is written, it is a style that they will follow across the world. The way Coca-Cola is written, the way Pepsi is written, if you look at any brand today, they are following a standardized trademark. Now, what happens is when you see that M that signifies McDonald's even from a distance, and you see that anywhere in the world, it will only convey one thing to you, that a McDonald's restaurant happens to be in this location. So a trademark will help you in identifying a particular service, okay, from a distance. No, Virat, a patent cannot be renewed after 20 years. It will go into the public domain. Now, certain words, letters, figures, colors, etc. are utilized by manufacturers, producers, service providers to attract and differentiate the quality of goods and services. A mark used to identify goods and services is known as a trademark. So, there are a lot of fast food chains not only in India but across the world. How does McDonald's become identifiable from even a distance? Because of their trademark. Clear? So in order to make a good or service identifiable, the company spend heavily, or the bitten apple, okay, the iPhones that you're using, their trademark is the bitten apple. So that happens to be their trademark. So that signifies an Apple product no matter where you go in the entire world. Now, how is a trademark defined as far as the Trademark Act in India is concerned? Khushi, you don't have to worry about the punishment, just focus on the concept right now, because you do not get such questions in CLAT. Clear? Megha, this is called passing off, and of course there is punishment for any infringement. That is a common principle that you all must know, that whenever a law is created and if you are going to violate it, there will always be some kind of punishment or compensation that you have to pay for it. Clear? Okay, Anshuman, if you are going to try to create a similar mark, then that concept is known as passing off. Okay, that you have created a similar mark so that people confuse your product with the popular product and buy your product. Clear? Now, it includes a trademark as per the Indian Trademark Act, includes a device, a brand, a heading, label, ticket, name, signature, word, letter, numerical, shape of goods. No, Anshuman, it's not allowed. Packaging or combination of colors or any combination thereof. Yes, Aditya, these rights are recognized worldwide. What are the essentials of a trademark? Okay, when you apply for a trademark, what are the few things, essential things that have to be kept in mind? A trademark has to be distinctive. That means it has to be different from the existing ones. I mean, the whole purpose of creating a trademark is to make sure that your good or your services can be identified. So if you are going to make a trademark which is very similar to an existing trademark, then it shows a bad intention on your part. You must have seen, then the Asian market today is flooded with replicas of first copies. That is an example of infringement or passing off. Okay, you must have seen fake Louis Vuitton bags in the market, fake Nike shoes, fake Adidas shoes. Now here they are copying the exact trademark, right? So these are replicas of first copies. So here they are violating the goodwill that has been created by the original brands in the market. A trademark should be an invented word, preferably. Okay, it should be easy to pronounce and it should be short. Yes, Anshuman, it is passing off. A trademark can be refused. So when you're trying to seek a trademark, it can be refused on the following grounds: that it's either deceptive or confusing. Okay, this is what we just discussed, that do not opt for a trademark which is similar to a trademark which already exists, a trademark which is likely to hurt religious sentiments, any scandalous or obscene mark, okay, or any mark which is prevented under the Emblems and Names Prevention and Improper Use Act of 1905. What is the term of a trademark? The term of a trademark is 10 years. And a trademark can be renewed for a further period of 10 years at a time, but you have to pay a renewal fees. We've already discussed infringement and passing off. Alright, now we're coming to a final segment of our e-lectures, that is family law. And as far as family law is concerned, I'm going to breeze through Hindu law and Muslim law. I'm going to discuss the basic essentials of a Hindu marriage, a Muslim marriage, and what are the various grounds for divorce under Hindu law and Muslim law. Now, at the end of this session, for whatever time we are going to be left till 8 o'clock, you can please bring in your queries. I'll be happy to discuss them with you. Now, when we talk about family law basically consists of 5 aspects. There is marriage, there's divorce, there's succession, there is adoption, and then there is maintenance. So as far as India is concerned, there is we are following the system of personal laws. Okay, as far as family law is concerned, Hindus are following their personal laws, Muslims are following their respective personal laws. The same goes for Christians and Parsis. Clear? Now That is why we discuss Article 44 under the Directive Principles of State Policy that talk about a uniform civil code. Yes, Anshuman, what about your queries? Anshuman, in the last 10 to 15 minutes, whatever time I'll be left with, because we dedicated an entire e-lecture to IPC, which has gone live on YouTube now. So I took all possible queries in that section. So if today I'll have some time, I'm going to take queries, okay? Otherwise, you'll have to go back and watch that lecture on YouTube. Clear? Now, who is a Hindu as per section 2? So, I'm sorry, I'll go back to Uniform Civil Code. Article 44 says that in India there should be a Uniform Civil Code. Currently, we do not have a Uniform Civil Code because every religion is following their own personal laws as far as marriage, divorce, adoption, maintenance and succession is concerned. So, India still has to attain that level where we can strive for a Uniform Civil Code. Now, who is a Hindu? Because we are talking about Hindu law right now regarding marriage and divorce. So we have to see exactly who are these people to whom the Hindu Marriage Act of 1955 applies. So Hindus, Sikhs, Jains and Buddhists. Anshuman, conversion is when you deal with somebody's movable property in a manner that you're not supposed to deal with. You might take it out of the possession of that property, or you might give the property that belongs to another individual to somebody else. Conversion is simply this. Okay? Can you please save all your queries for the end? Let me finish family law. Otherwise, your questions are going to go up in the text chat and I'll never see them. Okay, so please, when I'm going to ask you to start throwing in your queries, go ahead and do it. Hindus, Sikhs, Jains and Buddhists are included in the definition of Hindus. Now, all those people who are born to Hindus, Sikhs, Jains, Buddhist parents, whether they are legitimate or illegitimate, are also Hindus, and all those who are not Muslims, Christians, Parsis or Jews and are domiciled in India will also come under the definition of Hindus. Now, what are the essentials of a Hindu marriage? Well, first of all, Saptpadi, which means in common parlance in Hindi, you use the term Saath Fere. So the term is Saptpadi, that means the taking of 7 steps by a bridegroom and bride jointly before the sacred fire. Second, neither party should have a spouse living at the time of marriage. Okay, and both the parties, that is the bride and the bridegroom, should be in the mental state to give a valid consent. That is why the next point is talking about mental soundness. And the last criteria is age. So boy has to be 21 plus if he wants to get married as per the Hindu Marriage Act, and a girl has to be 18 plus if she wants to get married under the Hindu Marriage Act. Now, what are the various criteria for divorce as per the Hindu law? So, the first criteria is if the spouse starts living in adultery. That means he starts living with another, in case of a man, starts living with another woman. In case of woman, starts living with another man. Has ceased to be a Hindu by conversion. Yes, Vanshika, in court marriage there is no Saptpadi. Okay, court marriages do take place. That is a completely different concept altogether. But right now we are focusing on the personal laws. Clear? Anshuman, adultery can be done by a man also and by a woman also. Yes, Vanshika, it's legal. Has ceased to be a Hindu by conversion, incurably of an unsound mind. So when you file for a divorce, before that for at least 3 years your spouse should have had an unsound mind, should have suffered from a virulent and incurable form of leprosy, again not for a period that is less than 3 years, venereal disease in a communicable form, again 3 years, has not been heard of being alive for at least 7 years by those people who ideally would have known about the whereabouts of the person. Then non-resumption of cohabitation for a space of 2 years after the passing of decree of judicial separation. In the forthcoming slides, I will explain to you what judicial separation is. Or fail to comply with the decree of restitution of conjugal rights. This will also be explained in the forthcoming slides. Ma'am, is it legally amended from male 18 and female? No, Aditya, that's not correct. Yes, Virat, I will clear all the doubts at last. You do not have to say please. Just focus on the concepts that I'm trying to clarify right now. Okay? Muslim law. Now, as far as Muslims are concerned, the Muslim Personal Law Shariat Application Act 1937 will apply. Now, as far as the Hindu law is concerned, marriage is considered to be a combination of a contract and a holy sacrament. Before 1955, before the Hindu Marriage Act came into being, Hindu marriage was considered to be an indissoluble union. But later on, after 1955, they recognized the concept of divorce. As far as Muslim law is concerned, from the very beginning they've maintained that a Muslim marriage is contractual in nature and it's called nikah. Now, when we talk about a contract, there has to be proposal and acceptance, right? So in case of Muslim marriage, one party has to make a proposal and the other party has to accept that proposal. Then consideration is paid in the form of a mahar, that is a gift by the groom to the bride. Now, what are the other essentials for a Muslim marriage? Both the bride and the bridegroom have to have a sound mind. As far as Muslim law is concerned, Anshuman Mahar is simply an amount of money that is paid by the bridegroom to the bride at the time of marriage. Puberty, as per the Muslim law, they haven't really fixed an age like Hindu law, 18 for girls and 21 for boys. They say the minute a boy and a girl they hit puberty or they attain puberty, they are fit to get married, and again there has to be a free consent. What is the criteria for divorce as far as Muslim law is concerned? Now, a husband may divorce his wife by repudiating the marriage without giving any reason. When we discussed the various grounds for divorce under the Hindu Marriage Act, those grounds were open for the man as well as the woman. So a Hindu male or a Hindu female both can file for a divorce. But as far as Muslim law is concerned, a Muslim man can end or repudiate a marriage without giving any reason to the woman. Now, the pronouncement of such words which signify his intention to disown his wife is sufficient. So there is no set procedure by which a divorce can be taken as per the Muslim law. Any words which convey that he does not want to remain in a marital relationship with the wife are enough to conclude a divorce. What you need to know is, now a wife cannot divorce a husband on her own. She can divorce the husband only when the husband has delegated such a right to her under an agreement. Khula is when at the time of marriage the husband delegates this right to the wife that if she wants to seek a divorce, she may seek a divorce. And Mubarak is when both the husband and wife decide with mutual consent or mutual understanding that they want to take a divorce. Megha, the talaq ritual has not ended. In fact, the triple talaq is also still very prevalent in our country. I think you're referring to that, and Muslims can take talaq in various ways and not just one. Triple talaq is just one form. Talaq, the meaning of talaq is divorce. So how can the talaq ritual end? Okay, so the rituals, the divorce as a ritual has not ended. Triple talaq was under a lot of controversy where a man could divorce his wife by simply saying talaq thrice. That is still prevalent in India. So Megha, triple talaq is also still prevalent in India, and that is just one type or one method of taking divorce. Okay, that's not the only type, and even if that was the only type, it is still prevalent in our country. Now, before 1939, a Muslim wife had no right to seek divorce except on the ground of false charges of adultery, insanity or impotency. So prior to 1939, the three grounds on which a Muslim wife could seek divorce were adultery, insanity or impotency. After the dissolution of Muslim Marriage Act 1939, a few more grounds were added. Now there are a few concepts related to Hindu Marriage Act that you need to be very clear on. Now, first concept is under section 9, restitution of conjugal rights. Now, restitution of conjugal rights is an order which is given by the court when a husband and wife they stop living together Okay, then one of the parties can move to the court and make a request to the court to pass an order that either the husband or wife, whoever has started living separately, should be asked to come and start living with the spouse. So this is called the restitution of conjugal rights. Jobanpreet, you will have to get some more clarity on it, okay, because when Allahabad High Court gave this verdict, I know this case really well, they did not abolish triple talaq. It was one specific case where they said that this triple talaq which was given by the husband to the wife will not be valid because the husband did not follow the essential do's and don'ts which have been laid down under the Muslim law. So the Allahabad court has not abolished triple talaq. It was one specific case where they did not allow triple talaq because the essentials that have to be fulfilled for the triple talaq were not followed by the husband who had given the triple talaq. So this is a wrong statement that Allahabad High Court has abolished triple talaq. It is a personal law, personal Muslim law, and the judiciary cannot interfere with it. Clear? Then judicial separation. Judicial separation as per section 10 is whenever a party goes to seek a divorce. Before granting of divorce, a cooling off period is given, that is judicial separation, where the relationship of the husband and wife subsists between the parties, and this judicial separation time period is given for parties to rethink whether they want to go ahead with the divorce or not. And as far as section 125 of the Criminal Procedure Code is concerned, it talks about maintenance. So they say, Jobanpreet, conjugal rights are the rights that exist between a husband and wife. Okay, all the rights associated with marriage are known as conjugal rights. Clear? Maintenance. Section 125 of the Criminal Procedure Code deals with maintenance, and it says that a man is supposed to maintain his parents, his wife, his children, legitimate and illegitimate. A boy has to be maintained till the age of 18. He will only be maintained beyond the age of 18 if he is physically or mentally disabled or challenged. However, a daughter has to be maintained till the time she gets married. As far as adoption is concerned, adoption can be made under the Guardians and Wards Act of 1890. It applies to Hindus, Buddhists, Sikhs and Jains. Now, as far as adoption is concerned, the minor who is given for adoption, the giver, that is the parents, and the adopter all have to be in agreement. A female Hindu can adopt if she is of a sound mind, unmarried or married, and her husband is dead or has an unsound mind or is no longer a Hindu. So the bottom line is, a Hindu woman alone cannot take the decision of adopting a child until and unless she is unmarried, or her husband is dead, or the husband has an unsound mind, or the husband is no longer a Hindu. Anjani, maintenance means the money that has to be paid by a Hindu male for maintaining. The word or its implication remains the same, to maintain their day-to-day lives. Okay, it is the money that is paid under section 125 of CRPC. Adoption is, now only the father, mother or guardian can place the child for adoption. A child can be adopted if he or she is Hindu and has not been adopted previously and has not completed 15 years of age. When adopting a child of the opposite, the age gap has to be at least of 21 years. So, be very mindful of this, that a child who is about to get adopted should not have completed 15 years of age, and if a person is adopting the child of an opposite sex, the gap has to at least be of 21 years. Jobanpreet, you are saying, ma'am, in my legal knowledge book, there is a question that adultery and rape are not done by women. Is it true? Joban, adultery can be committed by a man also and by a woman also, but rape is a gender specific offense. It can only be committed against a woman. Okay. Purnima, alimony is the amount that is specifically paid by a spouse when a divorce is granted. So maintenance and alimony are two different things. Maintenance is something that you pay during the marriage. Okay, when the marriage subsists, when the marriage is continuing, and alimony is the money that is paid after a divorce takes place. Anjani, what do you need an example for? Also, I've ended my session, so please throw in your queries. We have about 10 minutes. Okay, Shraddha, a minor is a person who's below the age of 18. However, where a guardian administers the minor's property, the age of majority is 21. A minor is not permitted by law to enter into a contract. Hence, where a minor enters into a contract with a major person, the contract is not enforceable. This effectively means that neither the minor nor the other party can make any claim on the basis of the contract. Okay, I'm straight away going to the facts. Ajay convinces Banita, girl aged 18, that she would sell her land to him. Bandita's mother Charu is her guardian. Nonetheless, Bandita, without the permission of Charu, sells the land to Ajay for a total sum of rupees 50 lakh, paid in full and final settlement of the price. Charu challenges this transaction, claiming that Bandita is a minor and hence the possession of the land shall not be given to Ajay. Thus, Ajay is in a difficult situation and has no idea how to recover his money from Bandita. Ajay can be allowed to recover the money only if he can show that. Okay, so in this case, your safest answer would be the third option. In a contract with a minor, if the other party hands over any money or confers any other benefit on the minor, the same shall not be recoverable from the minor unless. So in this case, Ajay would have to prove that the party was deceived and the party was deceived and misrepresented her age. He was ignorant about the age of the minor and that he handed over the benefit on the basis of such representation, because we did under the Indian Contract Act that fraud is a ground for setting aside of a contract. No, Shraddha, ideally you should read. I read all the principles, by the way, and you should read all the principles too. There are a few questions that we've read before also, so we don't have to read them again and again. But please do not do what I just did. You must read all the principles. In fact, students, something that you can do is, whenever there is a very, very long list of principles, ideally read the factual situation first, because once you read the factual situation, you will get a clearer understanding of the principles. Clear? Because in CLAT or any other law entrance exam, a lot of times what will happen is you will not understand a single word of the principle that is given, right? So instead of getting confused at that time, quickly move on to the factual situation, and you will get, trust me, a lot of clarity as far as principles are concerned. Clear? Vanshika, as far as strict liability is concerned, strict liability is whenever you bring something, I have a very small request to make. Please simplify your queries for me, because I have very, very less time, and if you're going to just cut, copy, paste long questions for me, I'll be only able to take up 2 to 3 questions in these 10 minutes. So please simplify your queries, please simplify your doubts, shorten them up as much as you can. Okay? Strict liability, Vanshika, is when you bring anything that is of a dangerous nature onto your property, and if that dangerous substance escapes onto the other land, it could be smoke, fire, fumes, electricity, water, and it causes damage, then you may claim that you were not negligent, you were not careless, you did not intend any harm, but you will still be liable. This is what strict liability means. Shraddha, can you please shorten up this question for me? Virat, let me please read the question. Shraddha, the question said, what will Ajay need to prove if he has to get his money back? Okay, so Ajay has to prove that the age was misrepresented to him. Please read the question again. Look, please ask me concept based questions. I do not have time. Okay, Virat, your question is, passing off is a common law remedy being in substance and action for deceit. That is okay. Vijay Sales could not have entered the business of manufacturing and marketing. These are really long questions. I need you to just pause a little bit and stop throwing in more queries, because I need to read the entire question. Passing off is a common law remedy being in substance and action for deceit. That is a passing off by defendant of his own goods as those of the plaintiff. Infringement of trademark is a statutory remedy. Alright. Plaintiff shall be entitled. Dandi Salt Private Limited manufactured common salt under the unregistered trademark Dandi and has been in business for more than a decade. Vijay Sales Private Limited entered in the market and started to manufacture and market common salt under the trade name Great. Virat, I'm trying to read your question. 1 minute. Vijay Sales passed off goods in market claiming to be a sister concern. Okay, Dandi Salt is entitled to an injunction here. For question 2, your answer would be option 1. For question 3, your option would be 2. Virat, my suggestion to you is that, again, just like I told Shraddha, read the factual situation first, okay, and then read the principle. Now in this case, what you have to see is they have been in the salt industry for 10 years. Okay, when somebody else enters the market and tries to misuse their goodwill, the question is telling you very clearly that they were projecting themselves as a sister concern. Clear? Now in the second question, what happened is they are saying that if they had a registered trademark, then it would have been a clear violation. And in the third situation is, here, had they been dealing in the industry of fertilizers and chemicals, then salt and fertilizers and chemicals are dealing with two different kinds of markets. So here, none of them are trying to misuse the goodwill of each other. Clear? Alright, see, I will have to end my session. I just have one advice to all of you, that you will not enter the examination hall with this frame of mind that the questions are bigger than you or you are not intelligent enough to solve the questions. Trust me, the legal aptitude section happens to be the most common sense based section, and all you need to do is keep your head really calm when you'll be attempting these questions. You simply have to apply the law that is given to the factual situation. There are 35 questions which are straight away going to be based on principal fact scenario. Other 15 are going to be based on your current legal GK, so you can really score a lot if you keep your head calm and you keep applying the principles on the factual situation. I've told you, whenever the principles are going to be really long, first read the factual situation and then read the principle. Trust me, you will be able to solve your questions in half the time. Also, my advice to you is that try and attempt your English and your legal section in the very beginning, because they are slightly time consuming in comparison to the other 3 sections. So in these last 5 lectures, I've tried to breeze through the most important topics and subjects as far as legal aptitude was concerned. I hope all these sessions have helped you, and in case of any doubts and queries, you can keep writing into us, and just stay really positive, because no exam is bigger than your courage and your positivity. So I wish you all the very best, and I hope you all do really great things in life. Thank you so much for your time and attention, and take care.